Hello everyone, this is Gilbert Gillard. I'm talking to you here from CPLSPA downtown Orlando. This is Tufts on Tax, where all your tax questions and answers are right here with Mr. T. Scott Tufts. You can call him at 877-647-7887. Again, that number is 877-647-7887. Or you can email him at stufts@cplspa.com. That's STUFTS at cplspa.com. If you're watching YouTube, it's going to be on the banner in bottom of the screen, or you can actually go to our website at cplspa.com, and you will find his profile over there, and you have all our episodes, and also you can contact him. Hello, Scott. How are you today?
Good to be with you.
Good to be with you too. And today we are tackling S corporations and S elections. And what is that? This is new to me. So let's start with the S election.
Yeah, so we talk about entities having a certain type of tax treatment. The tax treatment for any corporation or LLC is subject to election. The folks who have small business out there or any kind of entity or structure will know the difference between an LLC and a corporation. However, what they may not realize is that a LLC can make an S election and be treated for federal tax purposes as an S corporation. So that gets kind of odd or different to them, because they have for many years, of course, understood that, hey, I'm a corporation or I'm an LLC. But when you tell them that your LLC may make an S election and be treated a different way than otherwise, so in other words, let's say you have an LLC, you have to look at how many owners there are. They're called members. And if there's more than one member, the default rule will be that if there's more than one member, that it will be a partnership. That's different from an S corp. So if that entity wants to be taxed as an S corporation, it can do so by filing an election with the IRS.
And that's why it's called election.
That's right.
That's why they named it that way. Okay.
So the operative term is I'm an S corporation is a term that you use for purposes of discussing tax issues. It is not something that you would find at the state level for the way you're formed. In other words, if you don't go to the state when you're starting to form an entity and say, I'd like to form a special kind of corporation called an S corporation. That has nothing to do with the state of Florida or any other state. That is actually an issue between you and the IRS.
I see. So what else we have to learn about this?
Well, so what happens is that now you get to ask, well, what is it that is advantages and disadvantages of being an S corporation?
Okay.
Right? Why would you want to be one, and why might you not want to be one? Okay. So those who are working in the area of picking the best entity, so when you go to form a business and you want to know what type of entity to elect, there are a number of factors that get into why you may choose one entity structure over another. So, for example, you may have state law considerations as to whether you would be a limited partnership, an LLLP, an LLLP, LLP. Those are types of limited partnerships. You would be looking at an LLC and whether you're member managed or manager managed, and then on a corporation basis, are you a corporation? Once you make that kind of decision, you then at the same time need to be thinking about the tax decision, which then flows from that, and again might determine what type are you familiar with. Maybe you have a long history of working with a corporation, and you've made S elections and you're comfortable with bylaws and articles and the terminology president, shareholder, director. Why would you jump into an LLC if you're going to be running the same type of business?
Well, so planning this is very important from the beginning, because you're thinking about taxes. You're thinking about that end road there. Well,
but there's going to be other aspects. So many people have, as they've gotten into these entity structures, realized that an LLC may be more optimal for asset protection than a corporation.
And I heard that a lot.
Right. So someone says, you really need to be an LLC, and they say, yeah, but I also want to be an S corporation. And they say, well, you can do that. You can be an LLC and obtain the benefits of better asset protection, but then that LLC can make an S election. What people forget, and this is kind of what we're focusing on today, is that if you have an LLC, its underlying document is the articles, but also the operating agreement, right? So you have an LLC operating agreement that is being utilized for S corporation purposes. You see what I'm saying? So it's not going to use the same terminology that an LLC that's being taxed as a partnership. So you have to make sure that you've got the right kind, and if you just kind of form it and don't ever look at your corporate book and don't execute on a well thought out, customized operating agreement, you might have a problem. And that's kind of what we're learning now. The IRS has come out with a revenue procedure 2022-19, and what they're trying to do is allow people a simplified procedure of fixing mistakes made. And one of the big mistakes that's being made out there is that they'll have an LLC operating agreement. They'll make an S election, but they don't go back and fix the terminology in the operating agreement to prevent violations of the S corporation rules. Because essentially what the S corporation is that not everybody can qualify for S corporation treatment. For example, if you're a non-citizen, non-resident shareholder, you are not eligible to have that in a S corporation. You're not eligible to have a partnership as a shareholder in an S corporation. Everything has to be a single class of stock, meaning you can't have a preferred stock and common stock. You have to have, everything has to be straight vanilla, if it were, or straight pro rata. And so what can happen is this language that is in an operating agreement that's geared for partnerships, that is flexible, will not conform to the requirements of an S corporation, and technically could violate the S election and could be a violation of the S rules. And make your S invalid from the get-go.
Wow, that leads to that.
Yeah, so essentially you would be blowing the S election because you didn't dot your I's and cross your T's, and you just used something that was boilerplate.
And does that happen a lot with people when?
Well, I would think certainly it happens a lot when you get started, and business is all about, the last thing you're thinking about maybe are taxes, and you want to get up and running. You're dealing with all the practical problems that come with starting a business and running a business, and you might not realize the importance of getting this part of the operation in check. Right?
So you have to think about your taxes regardless how. So just set it right.
Yeah, and here's the other problem too. If you go to a lawyer to set up an entity, or someone just sells it to you almost, or you get it out of a foreign book, are you sensitive to some of the particulars of your situation, and you don't, and you get it wrong because you don't know what folks like me know. Tax lawyer will know, okay, wait a minute, you've got all kinds of things going on here, you've got a problem. Is your agreement handling those situations? Operating agreements, just like corporations, need to anticipate the unexpected. It's kind of like a will. You go through all the hypotheticals you can to handle your particular situation. If you own a business, you say, what happens if I pass away? Are we ready for transition of the business? If I become disabled, are we ready for how that's going to be handled? If you get into an involuntary situation with creditors or some problem there, do we have that handled? Are we handling how we're going to get the information out to the owners? Do we have time deadlines on that? What about disputes? If you and I get in a dispute and we're in a LLC together, does the agreement carefully walk through how do we try and resolve our disputes short of going to court, right? And then what is it about how quickly do I have to get the information out to you? What do you do if you want to request information? Let's say you're an investor you're not really in the day-to-day business. How often do you get to participate in those decisions? Can you call a special meeting? You have a concern, over a situation. Can you call a meeting, right? What happens if we're 50-50 and we need to make a decision? How do we break a tie?
These are all important questions.
100%.
Yeah. And what triggered this subject today, this article that you found, that you were reading, the IRS
Yeah,
revision?
so it's the RevProc procedure that I mentioned, 2022-19. It provides the idea that if you've got a problem with your S corporation and you have a concern arise about your S election, is there a way to salvage it without having to go to the IRS in a expensive process that is what we call private letter ruling to fix it? And they've come up with, for certain situations, an easier fix. And this will save a lot of time and expense because you just need to adhere to the revenue procedure. But there are criteria on what it will cover and what it won't.
Of course.
Right. So not all S corporation problems can be fixed by this revenue procedure, but some can.
Okay.
And so what we want to get the word out is the IRS has put out this guidance that says if you've got an S corporation problem, don't bury your head in the sand. See if you qualify to fix it in this manner that's less expensive than another manner. The private letter ruling process, which we can do, but hopefully it can be done or fixed by us by this revenue procedure.
Awesome.
And that's pretty much true. Let me last say that's pretty much true for the IRS on all fronts. Is there you don't want to wait for the problem to rear its head by audit, right? You want to fix it and be proactive on the front end. And I think we've emphasized that, right? And I think over and over and over again we talk about being prompt. If a K1's wrong, get the 8082 filed. Before you file the 8082, go internal to try and fix the problem. But be proactive. The bad move is to do nothing and bury your head in the sand, right?
In medicine, the best treatment is prevention. Prevent to get sicker and be healthy. So in this one also, you have to, try to avoid.
And the temptation is that you don't want to deal with taxes.
Exactly.
You don't want to deal with health, right? Or necessarily
problems, yeah.
Right. So you have to get over that, I would say, and kind of be confident that you can get through this process, that sooner than later it's a better fix. And my experience is that, yes, it might cost you money to hire a lawyer to fix it or to address the issues or pay even an accountant and then the lawyer, and it might agonize you a bit for that and of course cost, the cost of hiring folks to do that. But in the end, that will be better than you wait and your problem is compounded by the IRS coming in and having an audit. Or it can come up also when there's a dispute between the parties and there's a problem with how it's been done and somebody says something then, because that then leads to all kinds of problems. So we have from the beginning in our shows here talked about the diligence and the promptness of getting to someone, because we've talked about the idea also that if you do nothing, you run the risk that you won't be able to fix it later, right? And that would be unfortunate, correct? So I think this revenue procedure helps get the word out, and we're going to continue to look for the IRS when they're coming out with guidance like this, so that we can get the word out to try and get to folks to say, hey, here's something you ought to be thinking about and be aware of.
That's true. I mean, it might be worth it to pay for the attorney. Make sure everything is correct. Hiring someone like you, and you're also part of the private corporate counsel that CPLS offers here as a program, and part of their, you guys helped a lot of businesses that they thought, I'm going to pay a lot of money of fees and everything, but no, just a monthly payment that you have access to legal assistance from attorneys like you and consultants that help them go through
I
these
think
things.
Where they can ask the question in a way that doesn't maybe it's kind of like you're chit-chatting on a golf course, or you're walking along somewhere. You have the opportunity to maybe discuss it more openly as part of a process that is allows you to speak up, that because maybe you don't even know you have a problem.
Exactly.
And you're able to talk in a way that in this kind of program where you can raise these questions. Am I good? And, I was wondering about this. I heard this. Is that something I need to worry about? So you can raise these questions, and then if it can be answered on the spot, fine. If it needs further analysis, then you can at least hear why and move it into that situation.
And it saves their business. God forbid anything goes wrong.
Yeah. So, and it breaks down the barrier perhaps of having to pay. So much of it is, do I have to call and make a doctor's appointment, right, and get fixed or looked at? And I go through all that angst of, I got to set up an appointment. I got to go through all this.
Exactly.
Whereas maybe if you're in constant dialogue,
yeah, it does help.
So maybe there's something that allows the dialogue to more freely reveal these things than a kind of huge meeting concept that maybe the old style. So this kind of goes in a better direction where through dialogue, because. Right? Like I'm amazed at how many settings there are where you can be in a different setting and you might freely talk in a social setting or whatever. Now you want to be careful with what you reveal, but
of course,
but for people out there who are struggling with getting questions asked, maybe you ask the dumb question in a more dialogue setting. That's actually not a dumb question and is actually an important question, and you're on the road to find out that you even have a problem and then fixing the problem.
End up avoiding the problem.
or preemptive and avoid a problem.
Yes. And
and that gets us to where we might try and go in future episodes. We're going to want to talk about preempting as best you can litigation. So part of the ability to operate as a business is to be pretty smart with what your contracts look like, your agreements, and make sure that you're ready for battle, although you hope you don't run into any battles.
Yes, absolutely. And I think next episode would be our last episode for this year, and then we'll resume.
Yes, we'll finish off
2023.
What season are we on?
Season 3, and we'll get to season 4.
So we'll wrap up the season 3, and then we'll go to season 4, and look forward to that.
More information, more taxes to deal with.
More excitement.
Yes. Well, you heard him, everyone. If you have any question, please call us at 877-647-7887. Again, 877-647-7887. You can tune in on YouTube, or you can actually go to our website, cplspa.com. You have Mr. T. Scott Tufts information and podcast episodes, and you can also email him at stufts@cplspa.com, stufts@cplspa.com, and we'll see you next time. Thank you.